My name is Nambitha Dambuza. I am a judge of the Supreme Court of Appeal, the Middle Appeal Court in the Republic of South Africa. I have been a judge for more than 20 years, and I have a particular interest in environmental law. My interest emanates from the fact that when most of us in the South African judiciary, and I guess in other jurisdictions as well, started our law school and we practiced, environmental law was not front and center in the conversations and the cases that we dealt with. And so my belief is that we need to capacitate ourselves as much as we can, because apart from the fact that we didn't study it at school, we didn't necessarily all practice in this area of the law. It is also a tricky area of the law. It involves quite a bit of scientific evidence, and therefore we need to know how we apply it and develop the best practices in this area of the law. In the cases that I've advocated before, the latest one is a judgment that we gave just about a month ago, and the judgment is usually referred to as the deadly air case. It is a case on the high levels of air pollution in one of our provinces in South Africa, where most of our coal-fired power stations are located. And my experience, and particularly in this case, is that women are at the center and are most affected by the effects of environmental harms. In this case, for example, in particular, it arose out of women noticing and experiencing illnesses that their children were experiencing. And therefore, just from talking amongst each other, they realized that the harms are actually in the air that they're breathing. And all the time when they were expecting children, they would have this anxiety as to how the child is going to come up. And because of the structure of our societies, women are the caregivers in the homes. And so it falls upon them most of the time to deal with the effects of environmental harms. And what has come out of it, the positive, is that the women in this country have started to become change makers. They are getting to organize themselves and being educating themselves about the causes of the environmental harms, both to health and just to their environment generally, because as well, they are the ones who tend to gardens, who provide food. They are the first port of call in all sustenance that is needed by their families. And therefore, they are rallying up, and we are seeing cases that are driven by women's stories of their practical life experiences. So that is the experiences that we are having in the South African judiciary in this area of the law. Look, first of all, I think, as I said, some of the effects of our way of life in the context in which we work immediately resonate in your mind with your life experiences as a judge. You are first and foremost a human being, and we also grew up in these communities. So this is the way of life that we also know. And so when we hear these stories, I think we have more insight than a person of a different gender, but well, that is debatable, I know. But I think I can say, by and large, we can extract general patterns of behavior with which then we resonate with what we know and make sense. And perhaps the outlook in fashioning orders that will be effective will also benefit from that kind of insight. And it is the insight that makes us, the principle of transformative constitutionalism makes sense to women judges, I think, in this sphere, because we understand, I think, innately. I hope I'm not arrogant, but we do understand what the transformative principles that we can fashion, that we can draw from these experiences, that we can infuse in the principles that we are designing specifically for gendered justice. Again, I would say it is a particular kind of equity. It is equity that has to peel away the layers. Normally, as adjudicators, we develop and adjudicate along certain general principles that have been set, and they will apply to a certain extent with adjustments with regard to societies, communities, but we haven't had, or I'm not aware of, a demand such as emanating from environmental harms and how they affect women particularly. And also because environmental justice is a new term, is a new concept. We need to also bear in mind all the time that we need a shift from thinking generally about societies, about communities, and think deeper in relation to particular sectors of societies, and in this case, women, because the evidence is there. It is set, and actually we see it in our daily lives of how women are at the forefront of communities, as I have said. And therefore, what is needed is a shift towards general thinking and a focus in this case, and paying particular attention to the gender, the gender personality of the evidence that we look at. Normally, we look at evidence mostly, except in particular gender cases such as rape and all, and such cases. But other than that, we normally look at those who are affected by conduct in more general form. And so we need to be aware of the required different thinking, of a deeper focus on the gendered nature of the evidence that we hear all the time, and that protection of the vulnerable people in this instance takes a different twist, which we must confront head on, and therefore start developing and thinking about bold principles that do not flinch from thinking about remedies that are entirely fashioned for women justice, women environmental justice attainment, ultimately. Yeah, the final word I think is that we need to talk more. We need to talk all the time as judicial officers that are entrusted with deciding these cases. We need to also be aware that our judgments will be teachings as well to communities, and how we express ourselves in our judgments will take a particular color in this context. And therefore, the more we have these conversations as women judges or judges that are interested in environmental gender justice, we need to share more in order to be aware of the different experiences of women all around the world, and also to empower each other and to share our own experiences, and then how in each jurisdiction we are sort of calibrating our approach to disputes, approach to advices that we give, approach to teachings that we give, in order to keep at the forefront of our minds particular pockets that may be hidden in some of the cases that we adjudicate, so that we are able, for example, because cases that serve before us are disputes between people, and therefore what comes before us is disputes that are colored by the interests of the litigants before us. So we must be able to draw out particular aspects of matters that come before us that do not necessarily appear at face value when we look at the cases before us. And we are in a constant drive for education, and also the sharing of experience that will strengthen us in the tentative steps that we are taking, because it's not going to be easy. It is not easy, taking into account the different strengths financially of the litigants that come before our courts. And therefore, the stronger we are in the knowledge in this area of the law, I think the better we will serve the communities that we adjudicate, in whose cases we adjudicate. And yeah, that's usually what really bugs me most, that I do feel that we struggle to be empowered, because there's no money for us to travel. There's no time for us to organize And therefore, when we get support, things become better. So we need as much support as we can get, either way. Thank you.